Okay. We are just waiting for everybody to get on here. And while we are waiting, I'm going to go ahead and get started with the baseline reminder for all of this. My name is James Greenwood. I am an attorney at Greenwood Law. It's my pleasure to have you here at the second to last IP at Lunch, a 10-minute micro webinar series for entrepreneurs, creators, and small businesses. As a reminder, this series and anything we talk about is for educational purposes only. It does not create a attorney-client relationship. We haven't agreed to represent you, and the only way to engage us is to actually sign a contract that our firm provides to you. Additionally, you should not use what we talk about on these webinars as legal advice, in large part because we're not talking about your specific situation. We don't have all the facts. You need to go talk to an attorney who's going to be able to ferret out your specific situation, your specific location, your specific information, and be able to assemble a good piece of legal advice in the event that you have specific questions. With me today, we will have Philip Schaefer. He is our IP co-counsel. I'm very excited to have Philip on. He should be joining us here in a he should be able to join us here in just a few minutes, it looks like. I was just looking at a message from him. And so we'll go ahead and just get started with the basics for today. And so today's focus and the key here for today is going to be IP and contracts, work for hire, assignments, and licensing. And so we're going to start just high level. What do we mean when we start talking about IP for contracts? Basically, IP for contracts are kind of what we want to talk about today is how do you get a hold of the IP in the first place? Who creates it? Who owns it? Who has a right to use it? And at the end of the day, IP is like any other piece of property, and every attorney in the world that I have ever met, at least, uses the analogy of a bundle of sticks. You can sell any piece of property, you can chunk it up, you can say, hey, this person has the right to use this piece of property either for 10 minutes a day or for 10,000 years, or you can say, oh, they can use it permanently, forever. They could say, oh, you only get to use it for 3 years, but you're otherwise unrestricted. They could use it for non-commercial purposes only. There can be a license for that. There can be all sorts of different controls and systems that we put in place. There can be rights that we parcel out related to our property. And so how do we do that? We do that with contracts. And so the big picture piece of this that I really want everybody to kind of take away is that just because you think you have something doesn't necessarily mean that you necessarily have it. You actually have to take a look at your licensing and your contracts and your agreements, your assignments, and that is going to be our big picture for today. Phil, thank you so much for joining us. A little background on Phil. Phil is our of counsel who focuses on IP. Phil focuses primarily on copyrights, trademarks, and he also does hard IP, which is kind of a unique skill set. That includes patents, and he is licensed to practice before the USPTO as a patent attorney. So, Phil, do you want to kind of get started with maybe why does an IP contract clause? So we've got this. Maybe you've got a deal. You're buying a business, and why do I care about the IP? I mean, who cares about that anyway?
Yeah. Well, James, I think the short answer to that is as it's business related, we care about money, and those IP rights or the underlying IP of an individual or a business is an asset that's worth potentially a lot of money, and so what we do with them or not do with them, with that property is very important to either maintaining, increasing, or preserving value.
Absolutely. And I'll give you a simple example. So we recently helped an individual buy a business, and that business, is a set of it could be it could be anything, but in this case, it was a set of storage units. What on God's green earth does IP have to do with storage units, you might ask? And
I'm curious
so
to know myself, James.
So, it turns out that the name of a business itself can be protectable intellectual property, right, Phil? I
That's
mean,
right. Yeah.
so what I mean, so along with the logos and any other miscellaneous stuff that these guys have developed. So you may say, oh, I'm just buying, Little Joe's smokehouse. And maybe that might be a bad example, but if there's something protectable or trademarkable there, you might need to obtain both the business itself and potentially, depending on how the IP is held, the underlying IP, because many times people will create um, the IP themselves individually, right? Because theoretically, let me give you a real world example that I've seen. So, guy creates a business. He hand draws personally the logo that he's going to use in the business. Who, Phil, if he hand draws that and he's not working necessarily for his business at the time, who owns the copyright?
So he would.
Yeah. And who owns the trademark?
Well,
Person in commerce,
yeah,
right?
yeah.
So the business may have a trademarkable interest, but if they don't own the copyright, then all of a sudden, it may not matter if they've got a trademarkable interest, because if they don't own the copyright and they don't have a license, they can't use it. I've seen that happen in real life. I had somebody get a demand letter from a guy saying, "Hey, that's my copyrighted material. You can't use that." What do you mean? We bought the business. You bought the business, but you didn't buy the copyrights.
Yeah. And
So
yeah, and that's, I mean, I'm glad you use storage units as an example. Because uh on its face, you wouldn't think that there would be much IP there, but most businesses have some sort of marketing materials that they use, and oftentimes there is some sort of trademark involved with that, as well as copyright uh, subject matter.
Yeah. So basically, just making sure that you cross all your T's, dot all your I's, especially when you're buying a business, and anytime you're buying a piece of commercial property. This is the other piece that many people who are new to the business world don't understand is when you're transacting in um, the real estate space and you're buying and selling residential housing, there are a ton of guardrails in place, and there's a lot of protection, and it's designed to be consumer friendly. But when we're talking about a piece of commercial property, it is not consumer friendly. In fact, many of the guardrails that you're used to having in place do not apply at all. And many of the protections, both federal and state, may be wholly inapplicable, and there may be um, uh, more complex issues at play, including IP issues that, if not properly addressed in the purchase agreement, may come back to bite you. So that's certainly something that we have seen in real life a few different times. So let's talk about a work for hire agreement. So let's use the example that we actually bumped into, where the guy had hand drawn that thing himself and sold the business, but never sold the copyright along with it. Um, we ended up working something out, but you know, it was an awkward kind of moment, and we came in after the deal was done. So anytime we're doing anytime an attorney is acting as a janitor, that's an expensive janitor, right? And that's the thing that I like to tell my clients is, you know, it's an expensive being the janitor is expensive. Working on the front end is relatively cheap. So let's talk about this idea of work for hire. So the example that I gave was, hey, he did this separately, he had the thing, then he sold the business, he kept the copyright, great. But what would have happened if he would have started that business up? He hires an employee, um, and that employee draws up their logo. Who owns that?
The company.
The company most of the time, right? So, but in order to make sure that the company owns it, many times, and I'm sure that people who are working in most fields, I know that even at Greenwood Law, we have a initial intake form that people sign, and it's got confidentiality clauses in there. It's got non-disclosure agreement in there. It's got some other provisions in there. But one of those provisions is it says, look, if you're on the clock and you're using my hardware, you're creating stuff, and that creation is copyrightable or trademarkable, we as the company own that. And it really provides clarity to folks um, as to who owns what. And so let's talk about a work for hire agreement. Can you talk about those more, maybe a little bit more broadly than just in the employment context? Phil, can you want to kind of hash through that, some of that stuff?
Yeah, absolutely. So, at work for hire could be, it might not even be business related, but you might commission a painter, for example. Um, uh, I guess one more relevant example would be wedding photography. To hire an individual to take your wedding photos. That the creation that they produce, a photograph, is copyright material. So they exist uh, quite ubiquitously throughout. I mean, not just business, but personal lives too. Um, Within them, there's and most people don't, they want to hire a wedding photographer. They don't go out and draft their own contract or even consult a lawyer to do so. Um, so I realize that, people don't run to their lawyers for everything, and that's just fine. There's typically some common provisions that are addressed in a work for hire agreement is, um, obviously who then owns it, what they're allowed to do with it, and then also too, if in the example of the um, wedding photography, if then the person being hired is able to use that as well for their own marketing materials, and that could be something that you don't necessarily care to have them do. So um, yeah, uh, there's a
So,
number of pieces to hit on within those agreements.
absolutely.
The
Yeah, and I
most
think
important being is who owns it.
yeah, absolutely. And I think that that ownership component and licensing component is really the subject of the um most of the fights that we end up having. And in fact, when I first started the firm, I negotiated a deal with a photographer about who owns our photographs and when they're allowed to be used for marketing. And we actually spelled all that out in our agreement. Um, and it was important to me to make sure that I had the ability to control those images on an ongoing basis and the usage of those. So we negotiated both the contract and the pricing around it, so that way we would be able to have that set control set around it, and but the photographer would still be able to use it for their marketing purposes. um, but maybe in our particular case, I didn't want them to be able to resell the license. So, and that was a big concern for me. I didn't want, there are a number of places, that actually, our illustrious, Ben Young has a photo that was taken of him, that, the photographer had subsequently licensed out through a stock marketing agency, and we found it used on another attorney's website. We have sent a takedown notice, and but haven't resolved that yet. So it was an interesting find, to say the least. Um, but certainly something that if his previous firm had owned the copyrights, they could have done perhaps a little bit more to have that resolved, instead of having a photographer be able to simply, place that up as a stock photo. So, in a very real sense, your business may benefit from negotiating carefully about the who owns the stock, or who owns the photo, or who owns the piece of copyrightable material, and what the licensing constraints may be on that ownership. And that can all be negotiated on the front end in a contract. Once the work is created, it is incredibly difficult to negotiate. And I think the funeral industry has a couple of great examples. There's a poem that is owned, and for the life of me, I just can't remember the name of it. But I ran into this the other day, and essentially, there's a poem and there's a video that they have, and a piece of music that they have, that they don't license to anybody, but it is designed for the funeral industry. And they basically, when they do license it, it is on a onesie twosie basis, and they charge an incredible amount of money for the usage on it. So I'll have to go find that now, because as I
Hmm.
rolling through my brain,
I wasn't aware of that.
but yeah, it's less than the penalty for violating the copyright, but more than you would really ever want to pay. And so I was talking to a friend who's a funeral director about that exact issue fairly recently. So certainly something to think about. So let's talk about. So we talked briefly about these work for hire agreements, and we've mentioned the IP assignment and the licensing agreements here and there. Can we just talk for a second? What's the difference between an assignment and a licensing agreement?
Who owns it at the end of the day? So, a license, you're granting use of, or yeah, some sort of right to, but you're maintaining ownership. Um, Assignment, you're changing, the ownership is changing hands.
Yeah. Okay. So yeah, okay. And then the license is just the right to use the thing. And that was what we mentioned in the front end, right? So I mean, licensing, we've talked about licensing throughout our kind of cycle on this. Um my
But
thought
that,
is,
I mean, that's a key distinction. I mean, yeah, you really want to get that language right, and be clear about what you're doing with any sort of rights transfer. Um, and there's, I mean, other places to record those assignments. Although I don't think that there's you're oftentimes recording licenses with our agencies. So trademark assignments could be, could be recorded, as well as patents, copyrights. So recording is another, thing you want to be aware of too, so that when you, let's say you want to get a hold of, a license to a piece of intellectual property, let's just say a trademark. You can go on the USPTO website, look to see the whole history of it, who originally uh, filed the application, but who is the current assignee,
absolutely.
and then
All
you
right.
know who to get a hold of too, then to negotiate that.
Yeah, absolutely. So let's talk about um planning. What are some things that you know maybe our folks who might create something um might want to have in place as they're starting to plan for who holds what. And I think there needs to be kind of a conversation about that up front, especially with a lot of these industries, because some places, I know that some corporations and some providers of this digital content, they don't negotiate on their contracts at all. They have a form contract, they expect you to use it, and if you don't use it, that's too darn bad, right?
Right.
Um, and so if you're in a pinch time wise and you need somebody to deliver something quickly, you're stuck. So it's important to go in ahead of time and plan for this type of thing. What are some planning considerations when people are thinking about, hey, what do I need to own maybe versus what can I just license? When does it make sense to own the copyright to something outright, or own that patent outright versus just get a license for it? I mean, what's the triggering kind of differentiating set of things that you can think of for that, Phil? I'd love to get your
Yeah.
thoughts.
Well, as with many things, you don't want to overpay. So that's what makes a license a good consideration in some circumstances, where if you only need like your onesie twosie um, funeral home example, if you only need a one-time use for something, you'd hate to procure the full ownership of the work, or the trademark or the patent, just for what your limited use will be. So I'd say that's probably the biggest consideration. But if there's and just going to patents, um, if you feel that something would be a core part of your business model, and you yourself may want to license that, or and I think price there too is a good consideration. Maybe it's something that hasn't been valued to its full potential yet, and you might be getting a deal on something. Then purchase and executing an assignment might be uh, a good approach. Um, I guess it's the big determinant is what value are you trying to get out of it at the time, and that helps guide that decision. Do I need something more limited? License would be the way to go, and oftentimes that would be much cheaper than buying something outright, the full ownership. But then again, there could be something there that warrants pursuing that could give you a good return.
Yeah, absolutely. And I think the other question, sometimes it's not direct monetary value. It's
Oh,
about
no.
control of the asset, right?
Yep,
And
yep,
so,
and that, yeah, I'm glad you mentioned that, because it's not just dollars and cents. There's intangible considerations there, probably more than there are dollars and cents, and control being, I mean, the operative word there.
yeah, absolutely. All right. Well, I think we've kind of hashed through. I haven't seen any questions come up, so I think at this point we're going to go ahead and wrap up for today. Again, my name is James Greenwood. With me, I have Phil Schaefer. He's our IP of counsel. I am licensed in Iowa and Illinois. Phil is licensed in Illinois and before the USPTO to practice patent law. If you have questions or concerns about today's webinar, you can call us at 855-528-6022, or email at web@greenwood.law. And as a reminder, this webinar, along with all of our webinars, is for educational purposes only. You should not use anything in the webinar as legal advice. If you do have legal questions, you should contact an attorney licensed in your jurisdiction, or that is licensed to practice before the body who you need representation before. Thank you so much for attending today's webinar. This was IP at Lunch. And my name is James Greenwood. With me, I have Phil Schaefer. Have a good day. Goodbye.
Thanks, James.